All right, the man of the hour is in the lobby, so he'll be up here in a second.
Good luck.
Okay, just a couple of things before Paul gets up there. He's on his way up from the lobby. Judge Jenneman emailed me. Her next quarterly newsletter is getting ready to come out, and want to know if anyone has any bar associations have any announcements by July 9th. So if you guys have anything you want to put into the quarterly newsletter, just give me an email, and I'll forward it up to Judge Jenneman's.
Might be a good idea. Whenever it comes out, you see what everybody else's bar associations are doing, and it's always silent for us. So
Yeah.
you know, whatever we're doing, ground roots, grassroots, let's put something in there at least.
Yeah, I'm thinking about putting something about Paul's speakers that were supposed to be here today, but couldn't make it due to a family medical issue. So they should be here
There's
next
Paul.
month, and so we'll put something in there about that, and obviously invite Tampa to come down and Orlando.
Or our extern program that we run down in Collier and Lee with dealing with Ave Maria, something there just so.
Yeah, if you'll shoot me an email about what's going on with it and things like that, I'll definitely forward it on. Pictures are fine, so if anyone has any events or something that they want to throw a picture up, we can do that.
Donations to my bank account.
I don't know if the judge is going to be down here
She's
today.
not coming
Not coming?
because she's driving back to Tampa. She's going to do her afternoon calendar from Tampa.
Okay, so no last word from the judge. So with that, I am going to apply for CLE credit for Paul's presentation. I'm just going to take notes on what he's doing and then submit it to the bar, so we'll get some CLE credit in the future for it. Okay? With that,
Did you mention anything about pro bono? Is that no clinic? No?
I'll let you guys.
I'll address that. All right. As you know, Bless has been formed, and the first year was organizational, the second year is fundraising, and the third year is when we start really doing the nuts and bolts of what Bless was designed to do. I've talked to Stephanie Carr about the other bar associations have pro bono clinics associated with law schools. She's an adjunct professor at Ave Maria, and we've talked about maybe getting a more formal clinic program established at Ave Maria, and I think Stephanie has mentioned.
But we can't call it a clinic.
Can't call it a clinic.
Why is that?
There's some roadblocks to that, which I guess I'll let Stephanie explain to everybody.
Actually, Laura Wesley of Ave Maria School of Law is here.
Even
and
better.
She can go into that, and we were just discussing it in the car. And would you go ahead and explain why the American Bar Association for Law Schools has certain requirements for clinics? And could you go into a little bit more?
Yeah, I mean,
Why don't we just call it doctor's office?
the problem is there's a process involved. So we have we have a clinics committee that's a part of the faculty. So a proposal would have to be made. It would have to be approved by the members of the committee assigned to review it. And part of what they would look at is whether it complied with various ABA requirements, which I do not know off the top of my head, but they would certainly look at that. We also, as I was explaining to Stephanie, we have space constraints, so I'm not quite sure. We have 2 clinics right now, and we're kind of bursting at the seams with them, so I'm not quite sure where we would host it. But we've been approached to do a veterans clinic and some other types of an estate planning clinic, and so far we haven't moved forward with either of those. So I'm just not sure. We could try, but it certainly wouldn't be the fastest.
What's the alternative?
The alternative we were talking about was maybe partnering with Lee County Bar and Collier County Bar, because although legal aid is wonderful, sometimes the turnaround's a little slow, and when you have a lot of moving parts, i.e. attorneys, volunteering their time, students who are trying to plan their schedules and summers and whatnot, a place, the software, all these moving parts, and then legal aid to plan the training. Legal aid was always a little slower in getting back to us with a commitment with respect to potential clients and a date for training. And I think we're doing it, well, we're doing it today.
We're doing it
but
tonight in
we're already
Collier.
almost halfway through the summer for students. So I had students who were interested in February for this. And they were waiting, because they plan their summer in advance. So they were waiting for a date when there would be a training and that we knew we were moving forward with it. So I'm looking for maybe Lisa Mead, Nancy Dubois. They manage a lot of different programs. Maybe this could be something that they could add to their roster.
How would a bankruptcy program, could we call it a bankruptcy program?
Just don't call it a clinic.
Okay. How would this bankruptcy doctor's office work?
We're welcome to suggestions. I mean, we were talking on the way, if I can add,
Yeah.
that remember when we did the mortgage foreclosure task force type thing? And, well, like the one tonight, what's going on is legal aid did the pre-screening of the clients to see that they meet the income standards.
We talked about partnering with Florida Rural perhaps to do that?
Well, again, with Florida Rural and the same thing with legal aid, they have their own internal processes. And for example, one of the secretaries at legal aid just quit. And that kind of threw the whole thing into a tailspin because she was very, very organized. And I think they're not really the most organized people. They have really good intentions and they do wonderful work. I don't mean to disparage them at all. But for this, it's going to be hard to get cases filed in less than 2 months. What we've seen in the past is the law students don't have the time and the energy once law school starts, obviously. You know, you saw that with your daughter. And you can remember when you were back in law school. So it tends to work best if we actually have it done primarily, a lot of the grunt work done in the summertime. Again, dealing with clients, that type of thing. But the way that it's been structured because of the organizational problems is now we have less than 2 months to get everything done, which is possible, but it makes it a lot more challenging. And I think what we had been talking about is trying to do more of an organizational structure, and Laura was talking about perhaps like a work study or something maybe in the future, something that is working with individual law firms. The bar, Collier County Bar, I know used to have those little, oh, please volunteer on Saturday morning, come in and talk to potential
Does
clients.
Anna Maria give credit for a course, credit for this type of program?
It depends. You could potentially do it as an externship and you get credit for it. You could, right now, we just have it structured as pro bono.
Is physical location at the school a necessity?
No,
So we could have it anywhere and they
yeah,
can,
yeah.
so we just,
I think legal aid in Collier had a program.
Yeah, well, we've been working with the externs from Ave Maria, and really we've been either using legal aid if it's been convenient for the people transportation-wise. Some of them don't have vehicles, so legal aid's kind of a good center for them to go. But I've had them in my office and, do what needs to be done, so we really don't need a fixed location necessarily. I mean, the logistics of the program, at least as far as tonight goes, is there's a brief presentation by the attorneys that have agreed to do the volunteer service. Then there are breakout sessions where you discuss it with and find out who's appropriate. And then, I believe they kind of randomly assign it to whomever is agreed to take on cases, so.
Correct. Whoever shows up, basically.
Yeah.
And the thing, the issue we face is, we're a smaller bar, we're a non-dues paying bar. In Tampa, they've got, I don't know how many members. They've got Stetson right there that has a bankruptcy clinic that's established. So when they look at us compared to them, we look like we're not doing much, but we just don't have the resources. And Ave Maria hasn't been around here long enough to have a clinic program established for all different disciplines. So it's something we've been talking about, but as far as a clinic, I don't think that that's probably realistic in the short term.
In the short term, aren't they required to do community service or pro bono, any type of hours to get their degree?
Not yet.
No.
So I mean, ultimately, we would want to have some type of externship where these law students get credit for doing this, because I know when I was in law school, if I had some free time, I wasn't volunteering.
But we
No
do-
offense to
but what we
anybody
do
who did
have
it.
is work study. So
Yeah.
if they're volunteering their time for legal aid, they can get paid $10 an hour for that. So they do have that option too, and it's a little bit,
And that's paid by whom?
the federal government, it's
Okay.
work study.
Okay.
That works out through the,
Yeah.
through the university. And the students I've been working with have been excellent.
And you know, the
Me
thing,
too.
what Bless can do is, pay for filing fees, service fees for these pro bono cases that are taken on,
Does the
sponsored
law
through
school
the
get them?
bar.
Does the law school get them sort of court approved of the steps they need to go through to get their qualifications to practice before the middle district in bankruptcy? Under the local rules?
No.
Okay, so you don't have that set up yet.
Well, you got that problem, you also have the production of paper. So you
How
need-
about confidentiality?
You need a
Your
program, you need
conflict checks and.
a paper, you need a bankruptcy program, you need a computer, you need a printer.
Yeah, and I know that Legal Aid in Collier has the program.
Well,
It's outdated.
that's been
It's
an
outdated.
issue.
And I've asked them several times to send me a grant request, and I haven't gotten anything. So,
What Greg and I have been doing in the past is we've had the law students, the ultimate responsibility lies with the attorney who's actually filing the case. And the law students actually come to our offices and use our computers and ask questions to us. Because we find that legal aid, even when Bless has offered to provide the funding, we never got a response back. And nobody at legal aid really knows how to work the programs anyway. They don't understand bankruptcy. They don't even really know how to do the intake. And it's just not something they do, and you know how specialized this is. So what has worked for us before is just having the law students come to our office at a mutually convenient time. We don't have the clients come to the office. And this is the way we've been doing this in the past, is if the students do the direct client contact. And they were amazing. One student I had last year, one of the clients was bipolar. I did not think that was going to work. But the student, she was amazing. I mean, if I needed somebody, I would hire her in a New York minute. She was able to sit down patiently with this client and get the information that she needed. And that's while she was going to summer school as well. And then they would come to the office and input the stuff in best case, and of course I renew my best case every year, and then ask me questions right there. And I think, Greg, you did pretty much the same.
I did, but I actually had the client come to the office. I
Okay.
did a review and sign with the client physically there. I just felt more comfortable having
Okay.
the direct control over the paperwork, so, yeah. But
Okay.
essentially the same thing.
Stephanie, can we put together, say, a couple, 2 or 3 people that are interested, maybe heading this project up, and then maybe getting something in writing as to what the issues are, figuring them out, and then that way, anyone else that's interested can look at what then figure out if they want to actually participate, and they know what they're getting involved in, and what they need to set up to do it.
I think you just need some physical space, the computers in the rooms, and and once you get that going, you can probably get the rest of it going pretty easily.
Yeah, it really, I mean, it hasn't been that much of an issue once you've established the intake. Once the attorneys establish the intake, then a lot of it is the attorneys acting as a mentor. And a lot of this is mentorship, and it's also getting the attorneys, or the young attorneys, involved in the local bar associations, the voluntary bar associations, which I know it's important to the bankruptcy bar. That one of the conferences, that was a big deal. They wanted to get more law students, young attorneys involved, as well as the Florida bar.
But I think we can put something in writing, like who to contact, and then what to
Sure.
expect, and we can maybe put that on our website, that way whoever interested can call up, know what to expect, what what they have to do to make sure that the students are complying with the school and that we're complying with
Sure.
local rules and things like that, and that way, you know.
And I think we were
Organized.
discussing that the issue or what we were relying upon legal aid for was the clients. So we had thought maybe the Bar Association would be another vehicle for
We
getting
got
those
a
out.
client that we can do pro bono, we
Right.
can look on the thing, contact you, get
Right.
a student in that's interested and get it
Right.
all arranged.
Right.
So we just need to know what process and steps to go
Right.
through, so it's a little clearer.
So that's the update on our pro bono
Maybe with
clinic efforts.
Bless what monies are available and how to
Yeah.
get the funds and things like
What
that.
is Bless designed specifically to do? I mean, just pro bono filings, or is there?
No, it's-
What is the global mission?
It's really, the purpose is to, one, it's called the Bankruptcy Law Education Series Foundation.
Mhm.
And
Also high school stuff, right?
Well,
yeah,
that's what I was gonna
yeah.
ask.
And it's basically to educate people on bankruptcy and bankruptcy procedures and provide an avenue for pro bono work. Like, let's say we have a seminar and everybody pays $20. We have a judge come to it. We give Bless $10 of that $20. That money is then used to fund education and pro bono initiatives. So if Bob calls Bless and says, "Hey, I've got this pro bono case. Here's the details. I need filing fees and money for mailing." That's something Bless would do, is they would fund that. Or if we said to Bless, "Hey, we want to put on a seminar for all the high school kids on, before they go off to college, on how
Not signing
to,
credit card
you know,
applications.
yeah, how to manage
Credit
debt and
cards.
not get into debt. And
Yeah.
we're gonna need $2,500 to put this together for advertising, flyers, and refreshments." That's something Bless would say, "Yes, that's a great idea," and, you know, speaking out of turn, but, and then say,
Yeah.
"Go forth,
Yeah, that's- yeah.
here's your money." You know, that's kind of the
That is a great idea.
thinking
by the way.
behind it, yeah.
That would be a great idea.
That's the CARE program, isn't it?
Yeah, there is a
Yeah.
program that you can.
Yeah, and our organization is modeled after
Use that credit card.
the similar foundation in the Southern District that Tom Masana put together years ago.
And Roy Coburn is digging that up in Orlando too.
Yeah, Roy actually helped us put together Bless. He and his former firm donated all the time for the incorporation, dealing with the IRS, getting tax
Is he now?
numbers, all that. Huh?
Is he on his own?
No, he went to
No,
he went to
Gray Robinson.
Gray Robinson. Yeah, he was at Broad and Cassell. So that's kind of where we're at. You know, and we have these meetings, and it's like, you know, Tampa Bay Bar, "Oh, we did this, that, and the other," and we're like, "Hey," you know. So it's hard to compete because we're so small.
You just wanna have something to talk about.
Yeah, we just need to have something to talk about. So let me get down to the case law updates. I've got some, with the help of David Feynman, we've pulled together some recent decisions that may or may not affect your practice, but they're interesting nonetheless. I'll start off with one that was an appeal from the Middle District of Florida. The 11th Circuit, it was Wells Fargo Bank versus Scantling. It's supposed to be published, but there isn't a citation yet. But if you go to the 11th Circuit website, it's number 13-10558. And this one basically supports the lien stripping in a Chapter 20 bankruptcy case. And the summary of the facts are: the debtor filed a voluntary petition for relief under Chapter 13 of the Bankruptcy Code seeking to determine the secured status of the second and third mortgages held by Wells Fargo on debtor's principal residence. The issue was whether the debtor could strip off a wholly unsecured junior mortgage in a Chapter 20 case. The court concluded that the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 did not prohibit this result. The court affirmed the bankruptcy court's determination that the debtor could strip off Wells Fargo's second and third liens on the residence because they were wholly unsecured. And it's a 14-page opinion. It's interesting because it goes through the history and how this has evolved. And they do cite a case that everybody's familiar with, the Dewsnup case, and they address that.
Did they distinguish that from Polendor?
Let me see. They distinguished it from Nobleman. but I don't think they addressed Ollendorf.
I think Folding was a cram down, not a strip off, so they might have.
Yeah, they didn't address that one.
They didn't deal with the issue of the chapter 13 discharge because it was already done in chapter 7, am I correct?
Here's what they said about that. The majority view recognizes a strip-off of the unsecured mortgage is allowed under the theory that a Chapter 13 debtor need not be eligible for a discharge in order to take advantage of the protections afforded by Chapter 13. A strip-off is worthless. Of a worthless lien is available under the Bankruptcy Code without a discharge. A debtor may take advantage of such relief. The court talked about the interrelation of 506 and 1322B. It stated that the Bankruptcy Code provides that when a debtor's junior liens are worthless and unsecured under 506A, 506 operates in tandem with 1322B to strip liens in Chapter 13 cases. BAPSIPA did not amend 506 or 1322B, so the analysis permitting lien stripping in Chapter 20 cases is no different than in any other Chapter 13 case. And then they addressed, what an allowed secured claim is, citing Davis saying, an allowed secured claim therefore merely describes a claim which is a right to payment or a right to an equitable remedy, as defined by 11 U.S.C. 1015, that is allowed, meaning not objected to by an interested party, and that is secured. The 11th Circuit kind of repeated itself on this one, talking about, it said that junior lien is not worthless if it remains allowed and secured by the debtor's real property, and the lien remains in this status after the debtor receives a Chapter 7 discharge. The in rem portion of the claim survives the debtor's Chapter 7 discharge, and the Chapter 13 plan must comply with 1325A5, and a junior mortgagee creditor has an allowed secured claim against the debtor's bankruptcy estate. Section 1325 provides that the debtor's Chapter 13 plan must provide that a junior mortgagee creditors retain their liens on the properties until the earlier full payment of the debtors in the context of non-bankruptcy law or a discharge. So it's said here that those sections 1325 and 1328F work in tandem to prohibit Chapter 20 debtor from stripping off a valueless junior mortgage. They were addressing what case was that? That was the Davis case they were addressing that was contrary to, I believe it was Newsom. So they basically said that we agree with the other circuits who have considered this issue that a debtor in a Chapter 13 setting may strip off an unsecured mortgage on the debtor's principal residence. The strip-off is accomplished through 506A valuation procedure that determines that the creditor does not hold the secured claim. Once this determination has been made pursuant to 1322B2, the creditor's rights are modified by avoiding the lien to which the creditor would otherwise be entitled under non-bankruptcy law. And they said that under such analysis, 1325A5 is not involved, and the debtor's ineligibility for a discharge is irrelevant to strip off in a Chapter 20 case.
So Paul, procedurally, and I guess Michael, you might be able to speak to this too, the order that gets entered, normally it references the entry of the discharge. It would probably be upon confirmation of the case.
It says upon plan completion.
Plan completion? Okay.
The standard order says the lien isn't stripped until the end of the case and the discharge is entered right now, right?
Right,
That's what you
yeah,
got.
yeah, that's what I'm saying, so it would be modified to say completion of the case rather than,
Shouldn't really matter.
well, that's what I'm saying, but you need a recordable
You
order.
already got the discharge, you got it on the side.
Correct,
But the standard order now says it's effective upon
on
discharge.
discharge.
Or other order of the court.
Or it says, or other
Under the
order of
code
the
that
court.
says you have to have the discharge. It shouldn't really matter.
Yeah, it says
Once you make
discharge
a
or other order.
determination, it should be stripped.
Well, other order of the court being the confirmation order then?
I guess you'd have to have it designated on the record.
Yeah,
The
probably,
court's-
Well, I think you guys probably need to bring it to the judge about the
Yeah.
formal order. to see
Yeah.
what she thinks.
I mean, this opinion is going to be published, so it'll be.
We'll have to find out, because
She'll
right
look at it,
now,
I'm sure, she'll probably have,
I don't know.
you know.
And what would-
when you-
and I don't know if you could speak to this at all, Mike, because I don't know if John's talked about it at all, but what about a chapter 13 designed exclusively to deal with this because you've discharged all of your debt in the 7? If you've got no other debt to administer, what's John's position gonna be on that? Do you have any idea or any take on that?
I think in this case, they filed their, within a year.
I think it'll all be moot pending on what happens in McNeil, but if McNeil gets overturned, then obviously more chapter 20s would be coming.
But it sounds like that they're gonna affirm McNeil, at least with some of the language in that
I mean,
ruling.
you guys have an allowed claim to receive no distribution?
Well, I think all the debt would be discharged in the prior 7, so there would be no other debt to affect. There would be no unsecured claim because the stripped lien was, the underlying debt was discharged in the 7.
Right, but if it's a timely filed secured claim, it would still be allowed, but it would receive no distributions.
Correct. Well, it would be determined to be unsecured. It would be a determination that the lien would be stripped, it would be unsecured, and effectively you have no other debt. So I don't know how the chapter 13's office would administer the case.
Fee only, fee only plan.
You have to have debt to have a 13.
Fee only plan.
That's what I'm saying.
But didn't the language you read say that they can avail themselves of the benefits of 13 even if there's no discharge right?
Yeah.
Yep.
So that's a benefit that's in 13, it's not just the discharge.
Right.
Right, but you gotta have some debt
But you have to have something
functionally.
to pay.
You have to have something to pay to the court.
Just make sure you have attorney's fees in there. And admin
Okay.
fee is a debt. You gotta have something to pay.
With something to pay, I would presume.
Have an admin expense.
Incur some more debt.
Yeah,
In the
you
gap.
incur a post-petition or a
You
post-discharge.
can't counsel
debt.
that.
Only secure.
The next case is actually from the Fourth Circuit, and I think it probably will never come into play here, because I don't see Chapter 7 trustees ever not doing what they're supposed to do. But
Not here.
the title of this news blurb is "The Fourth Circuit holds that Chapter 7 trustees are entitled to commission-based payments in the absence of extraordinary circumstances." And they addressed a reduction in a Chapter 7 trustee's fee by the court. The trustee moved for fees based on the commission system, and the court reduced the fee to the trustee, but it didn't give a factual basis why. It just said that, I'll read it here. In this case, the trustee requested a fee of $17,200. The bankruptcy court found that the trustee had failed to complete his duties properly or timely and reduced the fee to $8,020, which was the equivalent of a fee based on the trustee's hourly rate. The trustee appealed, and the district court affirmed the bankruptcy court's decision. Then the Fourth Circuit heard the issue. The Fourth Circuit stated that under Section 330A1, the court may award to a trustee reasonable compensation for actual necessary services rendered by the trustee, while Section 330A2 further provides that the court may award compensation that is less than the amount of the compensation that is requested. And then under BAPSIPA, Section 330A7 was added that
Shall be a
states,
commission.
in determining the amount of a reasonable compensation to be awarded to a trustee, the court shall treat such compensation as a commission based on Section 326. And then 326 sets out the scheme for payments to the trustee. The Fourth Circuit then discussed what extraordinary circumstances would allow for a reduction in the Section 326A rates. The court cited the handbook for the Chapter 7 trustees, in which the United States trustee states that extraordinary circumstances only arise where a trustee's administration falls below acceptable standards. Fourth Circuit pointed out that extraordinary circumstances isn't defined in the bankruptcy code, and stated that the court needs to have findings of fact. So it stated here let me find it here. Okay, in extraordinary circumstance, however, the bankruptcy court is nevertheless entitled to reduce the fee pursuant to Section 330A2. The bankruptcy court found that the trustee had not properly discharged his duties and that the trustee failed to administer the estate in an expeditious manner and neglected to adequately supervise the case. The bankruptcy court therefore based the trustee's compensation on an hourly rate rather than the commission-based rate. The Fourth Circuit found that this was legal error, and the bankruptcy court should have first determined the maximum statutory commission rate pursuant to 326A, and then determine whether extraordinary circumstances existed that would render the commission-based rate unreasonable. In the event of any reduction, the bankruptcy court should have made detailed findings of fact explaining the rational relationship between the amount of the commission and the type and level of services rendered. So, if you ever find yourself in that position, it's a two-step process, and the court has to specifically state the extraordinary circumstances to reduce the fee. That one is In Re Roe.
I think with the general, when they rewrote the code, they were trying to basically say that it is a commission unless, and because some of the courts around the country were saying, well, that's way too much money, even though that's what the statute says. And they said, no, it's commission. It's not a, it's not an hourly rate kind of thing. And basically what they're saying, unless there's an extraordinary, you need to demonstrate.
We can test it if you want.
Well, they didn't address, the court didn't address whether somebody representing an unsecured creditor could object to the trustee's fee. That's not in the context that it came about, but I would imagine that an unsecured creditor could object to Chapter 7's trustee's fee.
Yeah, but they're going to have to show extraordinary stuff.
Yeah,
is the
exactly.
whole point. It's not like, gee, that's a lot of money, therefore we shouldn't have to have that come off the top.
But here's a site if anybody wants to read that. It's 2014 Westlaw 1663329.
This is probably, but just a request that when you mention these cases, you just send us an email.
Yeah,
to all the
absolutely.
members.
Absolutely.
Make it so much easier because you miss one little thing and it's hard to find it later.
You got it. I will. We'll send out some of them aren't cited, so I think there's one that I will or have talked about that is is an unpublished opinion, so you have to use the case number of the 11th Circuit.
Kind of just a monthly procedure.
Let's see what else we want to talk about.
Is that yes or no?
What?
Sorry. He's not in charge, so.
Yeah, we'll send the sites out.
We usually do, I think.
We usually do
Yeah,
afterwards.
yeah.
Okay.
Here's another one, an appeal from the Middle District of Florida. It's Brooks v. Chase Bank. And in this one, the 11th Circuit reversed the district court's decision, reversing the bankruptcy court's decision remanding for determination of attorney's fees. The 11th Circuit stated that the bankruptcy court did not abuse its discretion when it refused to allow a bank to set off statutory damages and attorney's fees awarded under Florida Consumer Collection Practices Act against a pre-petition consumer credit card debt discharged in the bankruptcy. The 11th Circuit stated that the right to a set-off is not absolute, but rather is a permissive decision that lies within the sound discretion of the bankruptcy court. Validity of a set-off is determined under state law, and the bankruptcy code does not create an independent set-off right. Because Florida law does not mandate or prohibit set-off under FCCPA, it is entirely within the bankruptcy court's discretion whether to allow a set-off. The bankruptcy court's determinations that a set-off was not available because of lack of mutuality between an award under the penal statute and a debt discharge in bankruptcy, and the inequity of permitting set-off of FCCPA damages and attorney's fees against the debt that the creditor seeks to collect, because that would defeat the purpose of FCCPA. So here, what happened was the bank held a pre-petition claim against the debtor for approximately $30,000 for outstanding credit card debt, which was discharged through the bankruptcy. The Chapter 7 trustee brought an adversary complaint against the bank alleging that the bank violated FCCPA, and the bankruptcy court awarded $1,000 of statutory damages and statutorily mandated attorney's fees. And then the bankruptcy court denied the bank's request to set off the FCCPA award against the credit card debt. So the 11th Circuit basically said they need to try again and figure out what the attorney's fees are due under FCCPA, and that the set off is permissible. That one is not a published opinion. 11th Circuit, it's number 13-13538.
Paul, I'm sorry, that the holding was that it was permissible or that it was not permissible to set up?
It's not. I
Was not, right?
Was not
Was
permissible.
not.
not
They said that the
It's
bankruptcy
not, it's
court was-
permissive, not mandatory.
Okay.
Yeah, permissive, not mandatory.
Gotcha.
Here's an interesting one. This one is from this is a Supreme Court case, and it's Clark v. Remaker, trustee. And it's a slip opinion, so I don't have a citation for it as of yet. But basically, in this case, the Chapter 7 debtors tried to exclude $300,000 in an inherited IRA from the bankruptcy estate, saying that it was the exempt under the retirement funds exception of 11 U.S.C. 522 B3C. And the bankruptcy court concluded that an inherited IRA does not share the same characteristics as a traditional IRA and disallowed the exemption.
Sadly, Florida's statute supersedes that, I believe.
Yeah, they amended that one.
Yeah.
The district court reversed, the Seventh Circuit reversed the district court. The Supreme Court affirmed, holding that funds in inherited IRAs are not retirement funds within the meaning of the code, based on three characteristics. And those are that the inherited IRA holder may never invest additional money in the account. The holder is required to withdraw money from that account, and no matter how far the holder is from retirement, and may withdraw the entire account at any time and use it for any purpose without penalty. So what these people were trying to do is that the debtor inherited a $450,000 IRA from her mother, and they had to take monthly distributions from it. So by the time they filed bankruptcy, it was down to $300,000. They tried to exempt the entire amount, and they argued that it was retirement funds. And their lawyer had a creative argument. He said that, well, when these funds were put into this account, they were retirement funds, so they're still retirement funds. And the court said, no, that's not going to fly, because somebody could go and put money into an IRA account, file bankruptcy, assuming fraudulent transfers don't apply and all that good stuff, file bankruptcy, and then the day after their discharge, go buy a sports car with that money. So it was part of the property of the estate. So if you have any clients come in, maybe another question to ask.
Well, as I say, the statute overrules that in Florida.
Yeah, when would...
It says after Judge May and somebody else ruled the same thing. Yes, they amended it, and now if you read the statute, they add beneficiary of inherited, so I think that...
So it's exempt under Florida law?
It is exempt under Florida. At least that's how I read the statute.
Yeah, that's what we, yes.
Yeah.
We agree with you.
What is that?
We're all in 100% agreement with you.
So you may be
I
seeing
bet.
somebody challenging that under this law, this case.
Well, it'd be an interesting,
Yeah.
the argument, I've actually wondered about preemption, a little bit as to whether or not the fact that you're dealing with an ERISA statute, whether the fact that the Florida court amended the statute to sort of talk about being the beneficiary of what is essentially retirement plans, whether that could be arguably preempted by
But that would overcome the opt-out, wouldn't it?
Yeah.
Yeah, I know, that's why I'm not saying I'm gonna make the argument. It just occurred to me as an argument. I'm not sure it's one I'm gonna make, but.
Okay, now the next one is an interesting one. The name of the case, and it's a Ninth Circuit case, Burton versus Infinity Capital Management. And what happened in this case was, it's very convoluted, so I won't bore you. I'll try and put it in a nutshell, but basically there was a party that filed bankruptcy. And there were certain funds that were placed in the registry of the bankruptcy court because there was a disconnect as to who owned these funds. The debtor did not claim to own these funds as property of the estate, so they were put in the bankruptcy court's registry, and then another party filed an interpleader action in state court. So the debtor's bankruptcy counsel was summoned to this hearing by the state court judge. So he told the judge, my client filed for bankruptcy, he's not a party to these proceedings, the money's in with the registry, they need to file an interpleader, file something with the bankruptcy court, the stay applies, they can't go after my client. And the judge said, well, let's set a status conference for 2 months later, and we'll see where the bankruptcy's at. So 2 months later, everybody comes back except for the debtor's counsel because he doesn't have a dog in the fight, he thinks. So the judge is very upset that the debtor's counsel is not there. So he says, I want an order to show cause why he should not be held in contempt for being here and telling us what's going on with the bankruptcy case. So the judge says, who's going to prepare the order? And one of the lawyers says, I will, Judge. Big mistake.
I was gonna say.
So he prepares the order. He sends it over to debtor's counsel with a letter saying, the judge asked that I prepare this, here it is, giving him an opportunity to respond. What's funny about this is the order was never actually entered. But the debtor's attorney, on behalf of the debtor, filed a motion for violating the stay. And he named all the lawyers that were at the hearing,
Judge?
the judge.
Wow.
So the judge was dismissed because of pure judicial immunity.
Yeah.
And then the lawyer who prepared the order argued that, well, he was ordered to do this by the judge, so he too should be immune. And the court pulled the transcripts and saw that he volunteered, and they said, well, you kind of took this on your own. And they said that, basically it said that there was no he claimed he had quasi-judicial immunity. And the Ninth Circuit said that he did not.
Jeez.
And then here's kind of the synopsis, the blurb. A divided Ninth Circuit Court of Appeals has held that an attorney who prepares an order to show cause for a judge is not entitled to absolute quasi-judicial immunity. Although the function performed by such an attorney has a close nexus to the judicial process, in that show cause orders are prepared during judicial proceedings and are a basic and integral part of the proceedings, the preparation of these orders does not involve the kind of discretionary judgment that is protected by the immunity doctrine. The ultimate discretion determining whether an order will be integral to resolving a dispute lies with the judge, not the preparer. A dissenting judge disagreed that the drafting of the show cause order is simply a mechanical action comparable to a court reporter's transcribing verbatim transcripts, and lamented the fact that the majority opinion put at risk the common practice of private attorneys drafting proposed orders on behalf of judges.
Yeah, I can see you telling the judge, Judge, I can't do
Yeah,
that.
so-
You need to prepare your own order.
So that one is...
Well, that's what you do. You bring that opinion with you when you go to court.
So,
Say,
Paul-
Judge, you can't do that.
Did they make any light of if he had not first emailed it and just send it right to the chambers for signature?
No, they didn't address that. What they really harped on was the fact that he volunteered to do it.
Jeez,
So no good deed goes unpunished.
that's bad. That's really bad.
Yeah.
So who's going to do the order? I'd like you to choose, Judge.
Yeah. Make the judge.
Correct.
Next time you have to order you're asked to prepare a memorandum opinion in an adversary proceeding. Are you ordering me to do that, Judge? So,
Yeah, that may not save you either.
yeah. Let's see here.
And by the way, it doesn't matter if it's inside the bankruptcy or outside the bankruptcy, you can still violate a stay.
Now I've got some where I only have kind of blurbs, but not the actual cases. So I don't know if you guys want me to talk about those or just send you some information by email.
If there's anything really
Let me
cool,
see
tell
here.
us.
Oh, here we go. This one's interesting. Maybe I did pull this one. Yeah, here we go. Enrique Krauser, and it is 11th Circuit. It's not going to be published. Number 13-14304. In this one, the 11th Circuit held that the plain text of 1306A1 establishes that the proceeds of a settlement received by the debtor before the closure of the bankruptcy case are property of the estate. After the bankruptcy court confirmed the debtor's Chapter 13 plan to repay his creditors, the debtor commenced an adversary proceeding against his mortgagor for violating the automatic stay. The debtor and mortgagor entered into a settlement agreement, but the trustee for the debtor's estate argued that the proceeds of the settlement were property of the estate. And the bankruptcy court agreed with the trustee. The district court affirmed, and the 11th Circuit agreed.
Puts a very chilling effect on bringing sanctions motions.
Yeah. So
In 13.
it's a short opinion.
Mhm.
I could probably read it all to you guys right now if you want to hear it. Nah? Okay. But that one's kind of interesting. Let's see what else we have here.
I wonder if they had a claim in the case, whether they'd be excluded from distribution from the settlement proceeds.
It's silent,
Is it?
yeah.
Huh. And then that's just giving the offending creditor money back on what they did. That's wrong.
Yep.
Let's see here.
Good reason to settle with Chapter 13 trustee.
Here's another one this one's very long, and I read it twice, and I'm sure I still missed a few points in it. D. Giacomo versus Traverse. And in this one, the debtor secured a loan with a mortgage on her home, and she stayed current on all her mortgage payments on the property. She had a first and second mortgage. The bank, however, failed to record the mortgage with the appropriate registry. This was all in Massachusetts, by the way. I think they call it the Registry of Deeds up there.
Yep.
Yeah. In 2011, the debtor filed a petition for Chapter 7 bankruptcy. Although her home was subject to the homestead exemption, the trustee of the debtor's bankruptcy estate sought to sell the home as property of the bankruptcy estate, and accordingly, the trustee filed a complaint to avoid the unrecorded mortgage and to preserve it for the benefit of the estate. The bankruptcy court granted summary judgment for the trustee, and the bankruptcy appellate panel affirmed. The First Circuit reversed, holding that the trustee's lien, avoidance, and preservation powers did not justify him in selling the debtor's home as property of the bankruptcy estate. The trustee was the Massachusetts homestead exemption is $500,000, and the house was worth about $233,000 with the first mortgage of approximately $185,000, I want to say. So what the trustee tried to do is avoid the mortgage and then sell the property. And it's a 22-page opinion. And they basically, what it boiled down to was that generally a Chapter 7 trustee is not going to sell assets just to pay off secured creditors. And the court stated here that, let's say there was equity in the property beyond the first lien and the homestead, then the trustee could sell the property, but she would have to pay first the lien and then satisfy the debtor up to the homestead amount, $500,000, and then anything left over would go to unsecured creditors. And I have to read what the trustee was arguing here.
They stood in the shoes of the
They stood-
voided mortgage
yeah.
and had priority over the exemption and the second.
Yeah, this one's actually this one's worth a read. Let me see here.
I mean, I see the argument, but
The issue raised by this case is not whether Traverse's homestead exemption withdrew her home or merely the right to its proceeds from the property of the estate. The issue is whether a trustee's powers of sale under 363 justify selling a debtor's asset where no equity remains for the estate beyond the senior claims of secured creditors and the debtor's own exempt interest. The distinction may be best illustrated by the fact that the issue facing us today could arise even if there were no homestead exemption involved. Imagine, for example, a case where the debtor fails to claim any homestead exemption, but the full value of her home falls short of her undefaulted mortgages on the property. In this scenario, even absent any debates about whether the debtor had withdrawn her home or merely an interest in her home from the bankruptcy estate, the trustee's 363 powers would not justify selling the asset because there would be no residual equity in the property for unsecured creditors. The trustee himself admits as much as he acknowledges that he would not sell Traverse's home if both her mortgages remained with their banks, even though, under his own reading of Schwab, the home is technically property of the estate. The trustee suggests that his preservation of Traverse's first mortgage for the bankruptcy estate makes this case different. He insists that the preserved mortgage empowers him to sell Traverse's home because with the bankruptcy estate now standing in the shoes of the secured lien holder, the sale would directly benefit the unsecured creditors. Just because the preserved mortgage entitles the estate to the benefit from the sale of Traverse's property, however, does not mean that the trustee is by that fact empowered to sell the property so as to immediately realize that benefit. And the court said, in itself, a mortgage carries neither a right of immediate ownership of property nor a right of immediate payment of the secured loan outstanding value, but only a right to foreclose on Traverse's property in the event that she defaults on her loan or to receive payment in full when the home is sold through other means. And that is the extent of the rights gained by the estate by and through the trustee's preservation.
So as long as the mortgage was current,
As long as
it really didn't do anything.
Yeah, as long as it's current.
To stand in the shoes.
Not much you can do about it.
Collect the mortgage payment.
Yeah, I mean, you could think they could collect the mortgage payments.
And here's the thing, it's funny you mention that.
Yeah.
The court stated in a footnote, the parties in this case have presented to us no issue regarding who is entitled to Traverse's post-petition payments.
Yeah, I mean, I'm not sure that the trustee wouldn't be entitled to that.
Absent a separate agreement to the contrary, avoidance and preservation of security interest do not entitle the trustee to payments on the underlying debt.
Absent what?
Absent a separate agreement to the contrary, avoidance and preservation of a security interest do not entitle the trustee to payments on the underlying debt. And there's some citations there. So this one, I think, this one's worth reading. It was pretty interesting.
The First Circuit case?
This is a First Circuit case.
Yeah, it's on, the trustee has filed a motion for rehearing.
Heather. Okay. So, I guess with that, I'll end it for the day.
Thank you.
All right, thanks, Paul. All right, and I'll get these sites to,
I got them written down.
You got them? Okay.
Yeah. There was one other 11th Circuit came out. It's very fact intensive on a Ponzi scheme, Chapter 7. Trustees may want to read it. It's Weon v. Lee.
What's it called?
Weon v. Lee. I'll
For
throw
wine.
the site out there
The name down.
as well.
Oh. Yeah,
And then,
you need that one?
There's a couple state court, district court opinions too on fraudulent transfers that may be relevant for you guys as well that you want to check out. Other than that, I guess next month we're meeting and your receivership people are supposed to be here, right?
Yeah, we
We have a date
don't know if we're gonna do it. I think we're gonna do it in August.
in August.
Because I think he's gonna be gone and I'm gonna be gone
Okay.
for the
I think
July.
it's going to the bar meeting, there's a bench bar conference on Wednesday afternoon, and the business law section meets Thursday morning. I think it's next week, if you're going.
Is that the annual convention?
That's the
Isn't
annual.
before the bar-
That's the annual meeting.
That's the annual meeting, this is the annual, they're coming up, so the end of June.
Next week.
Gaylord Palms.
And then for those that didn't see the email, Mr. Hollander's got an issue that he's feels very near and dear to his heart. So if you have anything like that facing you regarding first mortgage creditor coming back after a debtor in a Chapter 13 case where it was a pay direct and claiming that the debt was not discharged, get with Mr. Hollander on that, and he can talk to you about some of the issues that he's raising on those cases. Beyond that, again, if there's any announcements that you want to put into the quarterly newsletter, July 9th is the deadline. Shoot me an email about it, and we'll get it put in there. All right,
I
thank
have a question.
Yeah.
Okay, other than Paul and Greg and Bob, does anybody else want to be on our pro bono committee that sets us up? Richard? Anybody else? Okay, good. Thanks.
All right, thanks, guys.
Thank you.